Good morning. Happy Tuesday. Happy Veterans Day. Welcome to the Courtroom Files Live. I am back. Thank heavens, thank goodness. I have missed you guys tremendously. Wanted to get started yesterday. Unfortunately, we weren't able to, but happy to be here. Thank you to Michael Groff for filling in for me for 2 weeks. Very much appreciated. Thank you to everybody for all the well wishes that you've given to my wife, Beth. As many of you know, she broke her leg while we were out on our vacation. And I appreciate all the thoughts and prayers and everything else you guys have given there. Let's get started in Oakland County, Michigan. This is Magistrate Corey Ellwanger doing first appearances, I believe. This is Veterans Day, so it's going to be an interesting day in the court, but we'll see what we can find.
Was moving here. He had only been here a day before he came into custody. It's my understanding that he has a bachelor's degree in business administration from the University of San Diego. He has no prior felonies or misdemeanors. He is 59 years old. He was planning on purchasing a home, and he is semi-retired. Based upon the fact that he has no prior contacts with the law, I believe a personal bond would be appropriate at this time.
All right, thank you, counsel. Detective, is there anything you'd like to state regarding bond in this matter?
No, Your Honor.
All right. Mr. Black, do you have any prior criminal convictions at all?
No, I do not.
All right. All right. Where are you residing here in Michigan?
Right now, I was heading to a hotel to stay, and then I was going to look for a home to purchase.
All right. Are you? Do you have a job here, or is there? I guess.
Well, I was going to refurbish a home, maybe try and get into the flipping of homes, fixing them up and selling them. However, if I did need to get a job, I could get a job. I have an extensive history in public transportation, particularly paratransit as a supervisor. I could always do that if need be, depending on the housing situation.
Well, obviously, and you're coming from Las Vegas, is that correct? That's where you moved from?
I was moving from Florida up here, and I put all my stuff in storage here in Michigan.
Well, I do not see any prior criminal convictions or prior failure to appear history, but we'll note, obviously, there's no ties to the community here. So there obviously are 4 felony counts alleged in this matter. I want to make sure that Mr. Black is going to appear in court. So in order to ensure his appearance, I'm going to set bond in the amount of $5,000 cash or surety. I will allow a 10% provision. I'm also ordering the following conditions. You are to have no contact with Shiana Etheridge or Erica Hallam. You will personally appear for any and all future court proceedings. You will not leave the state of Michigan without permission of the court. You will immediately notify the court in writing of any change to your address or telephone number. You shall not possess any firearms or other dangerous weapons. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abusing any legally prescribed medication. You will submit to random testing, which will include 1 ETG per week, as well as 1 controlled substance urinalysis test per week. You will be monitored by pretrial services supervision. So if you post bond, you have to contact pretrial services within 24 hours of your release, and their phone number will be listed on the bond form that you receive later this morning. Lastly, no new criminal offenses or activity. So Mr. Black, do you understand the terms and conditions of your bond?
Yes, sir. Yes, Your Honor, I do.
Do you have any questions?
No.
Okay, just so you're aware, your next court date is currently scheduled for November 17th at 9 a.m. That will be at the 52-4 District Court in Troy.
Okay. 17th.
All right, so Mr. Black, that is all for today. I wish you the best of luck.
Your Honor,
Thank you.
may I ask, as far as the no contact with the co-defendant, what about transport to and from Oakland County Jail?
I guess I'll leave that to whatever's easiest for you guys. If you have to transport them together to make it easier for you, I guess I don't have a problem with that. But
Okay.
Mr. Black, even if you are transported to OCJ together, you are not to have any contact with her. So do not speak with her. You understand that?
Yes, sir.
Thank you, Your
All
Honor.
right.
Thank you.
Thank you, Detective.
Okay.
And they're gonna bring out Miss Hella next.
Perfect. Thank you.
Entrance in.
Now calling prosecutor order number 25-13127, the people versus Erica Jocelyn Hallett. This is the date and time set for arraignment. Counsel, your appearance.
Attorney Monique Sanford, P62315, on behalf of Erica Hallett, waive formal reading. Client stands mute.
Thank you, counsel. The court will waive formal reading and enter a plea of not guilty on behalf of Ms. Hallett. Ms. Hallett, I did receive the request for court-appointed attorney form that you filled out and submitted. Based on your representations, I do find that you qualify for court-appointed counsel, so I will appoint an attorney for you moving forward, okay?
Okay.
All right, counsel's release the bond. What would you like to state on behalf of Ms. Hallett?
Your Honor, Ms. Hallett had just moved here to Michigan. She had only been here a day before she came into custody. She had packed all of her stuff. Their stuff was placed in storage in order for them to move here and reside. She is 43 years old. It's my understanding she's had a few prior contacts with the law. I'd ask for the court to consider giving her a personal bond and that she would be monitored by pretrial services.
Thank you, counsel. Detective, anything you'd like to say regarding bond in this matter?
No, Your Honor.
All right. Obviously, I just did the arraignment for the co-defendant, Mr. Black. At least 2 prior convictions out of Las Vegas. One for involving larceny, the other involving the use or possession of controlled substance. We now 2 counts of possession of controlled substance here. Based on the lack of ties to the community, I want to make sure that Ms. Hallett is going to appear in court. So in order to ensure her appearance, I'm going to set bond the amount of $5,000 cash or surety. I will allow a 10% provision. And I'm also ordering the following conditions. You are to have no contact with Shiana Etheridge or Thomas Black. You will personally appear for any and all future court proceedings. You will not leave the state of Michigan without permission of the court. You will immediately notify the court in writing of any change to your address or telephone number. You shall not possess any firearms or other dangerous weapons. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abusing any legally prescribed medication. You will submit to random testing, which will include one ETG per week, as well as one controlled substance urinalysis test per week.
Sure.
You will be under pretrial services supervision, which means if you post bond, you must contact pretrial services within 24 hours of your release. Their phone number is on the bond form that you will receive later this morning. I'm also going to order that if you do post bond, you have to enter the Step Forward program immediately upon your release. Their phone number will also be given to you so that you can set that up. Lastly, no new criminal offenses or activity. So
Absolutely.
Ms. Hallop, do you understand the terms and conditions of your bond?
Yes, I do.
Okay. Just so you're aware, your next court date is currently scheduled for November 17th at 9 a.m. That'll be at the 52-4 District Court in Troy, okay?
I'm not too sure what it is.
Be in this district court is what's your next hearing.
So Steve, you see what's saying? I don't understand. Like so
I'll explain it to you.
all right, okay. Okay,
And that is all for today, Ms. Hallop. I wish you the best of luck.
all right, thank you.
Thank you, Your Honor. Have a great day.
Thank you, Detective. Same to you.
Thanks.
Okay, I'm gonna log into Bluefield Township next.
Okay, sounds great. Thank you so much.
Good morning once again, everybody. Happy Veterans Day. Welcome to the Courtroom Files Live. We are currently live with Magistrate Cody Ellwanger here in Oakland County. There's not a whole ton live going on, so at some points today we will go to the Memorex, but we'll go ahead and hang here for a little while. Actually, change of plans, friends. So, as previously explained, Mrs. TCF broke her leg last week. She still requires my help with certain things, and she needs my help with something. So, what we're going to do is we're going to go over to the Wayback Machine, and this is yesterday with Judge Collada in Ohio. And I'm going to leave you with his hearing whilst I go help her with something. So I will be back, but enjoy Judge Collada here for a few minutes.
We're here this afternoon in the state of Ohio versus Robert Gravatt in case number 25CR52. The defendant is present in open court with his attorney, Mr. Watson. We are here today for a change of plea. It is the state's understanding that the defendant is going to plead guilty to an amended count 1. Your Honor, count 1 reads aggravated possession of drugs, a felony of the 3rd degree. That is a mistake. It should be a felony of the 5th degree. I would move to amend the language so that it states the amount of amphetamine does not equal or exceed the bulk amount. It was indicted incorrectly. It can be no more than an F5. So the state would move to amend that, and he will plead to that charge as an F5. There is no agreement as to sentencing at this time.
So the amount did not equal or exceed the bulk amount?
It did not, Your Honor.
The drug we're dealing with is amphetamine, not methamphetamine.
It is amphetamine. That part is correct. Just the bulk amount was incorrect.
That's a Schedule 2 controlled substance still?
Yes.
So Mr. Watson, I'm assuming there's no objection there?
You have no objection, Your Honor.
And that will be granted. Give me 1 second, please. All right, Ms. Contra, was there any discussion or part of this plea that deals with sentencing recommendation?
No, Your Honor.
So each side can recommend what they want?
Yes, and as Mr. Watson and I are aware, there are new charges coming that we're going to be discussing.
Okay. Mr. Watson, is that all accurate?
Thank you, Your Honor. May it please the court, yes, that's my understanding of this afternoon's hearing. I've had a chance to discuss this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with Mr. Herbatin. He has indicated to me that he is prepared to enter a change of plea as just outlined by the state. He understands that by entering a change of plea, he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor. And as the state just indicated, there is another case coming down, and I do believe will inform the court about a possible plea by information on that one, Your Honor.
Thank you. Mr. Herbatin, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this afternoon?
Yes, Your Honor.
Indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to the charge as amended, being aggravated possession of drugs, a felony of the 5th degree. You would then defer sentencing, get some updated reports completed, come back on a future day where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. All right, let's get started then. How old are you, sir?
46.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, prior to coming into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
Just like my blood pressure, and that's pretty much it.
Blood pressure medication?
Yes.
No other type of medications prescribed?
No.
Now, you would have received a copy of the indictment in this case. It looks like you probably got it around the end of March of this year. That's the document that sets forth the specific charge you're accused of committing. Do you remember getting that?
Yes, sir.
And did you have the chance at some point to review that?
Yes, sir.
Now, the indictment has been amended to reflect the correct charge, and how it reads as amended is on or about December 21st, 2024 in Lake County, Ohio, that you did knowingly obtain, possess, or use amphetamine or a compound mixture, preparation, or substance containing amphetamine, which is a Schedule II controlled substance. The amount involved did not equal or exceed the bulk amount, was less than the bulk amount, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about it?
No, sir.
Now, there's also what we call a forfeiture specification. That's a part of this charge that alleges during the commission of the offense you possess or hand interest in property considered to be contraband or an instrumentality Contraband is property that's illegal just by the nature of the property itself, like drugs. Whereas an instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used in an illegal manner to facilitate a crime. And you can't possess it for that purpose. And here it's alleged that all the drugs that were seized, along with associated instrumentalities, like any paraphernalia, if there was any that was seized. The whole point of this is it allows the state to forfeit this property, forfeit any ownership interest you have in it, so it allows them to dispose of it. It doesn't increase any possible penalty you face. It just gives them the opportunity to be able to dispose of it. Understand that?
Yes, sir.
Any questions about it?
No, sir.
Well, then before I can accept your plea, I need to make sure you understand the rights you are giving up, and you first of all have a right to a trial. And a trial could be to me as a judge, or I listen to the evidence and I make that decision ultimately whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. They would consider and weigh all that evidence, and then those jurors would make that ultimate decision. That ultimate decision reached by the jurors would have to be unanimous, which means all 12 jurors would have to agree together, one way or the other, whether you were guilty or not guilty of this charge. You understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you can ever be found guilty. You're presumed innocent of this charge. Presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when we speak of this burden of proof, since this is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden there is in our justice system. What it actually means, it's the amount of the evidence or the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge I just read to you as amended beyond any reasonable doubt before you could ever be found guilty of that charge. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, to prove you guilty, if we had a trial, the state would be bringing witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to, but within certain rules. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. You understand that?
Yes, sir.
And since that's your choice, solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial. If you don't want to, I can't make you testify. But more importantly, the prosecutor here would not be allowed to call you as a witness at your trial and make you get up on the stand and answer questions and testify. Your own lawyer couldn't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, I understand.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree, which is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, you're currently on probation or parole to the courts or agencies?
No, sir.
You have new pending charges against you?
Yes, sir.
Felony charges, I'm assuming?
Yes, sir.
What's the status of those?
I think we should, we're going to have an information filed.
Oh, they've been bound over then?
Yeah, they have. I got them on Friday.
What's the charge? Or
Aggravated
if charge is, I don't know.
possession of drugs and receiving stolen property.
What degrees?
F5s.
Both of them?
Yes.
If a prison sentence is imposed in this case, and you're being sentenced at the same time in another felony case, if that were to happen, I could run a prison term in this case concurrent or consecutive to a prison term in the other case. But that can only happen if you're being sentenced on both cases at the same time. I can't sentence you to consecutive sentences on this case if you're not being sentenced or you haven't been sentenced yet in the other case. You understand that?
Yes, sir.
Now, if you're sentenced on this case, and the other one comes around and you ultimately get being sentenced, that one can be consecutive, but I can't do this case unless you're being there at the same time. You understand that?
Yes, sir.
If a prison sentence is imposed in this case upon your release from prison, you could be placed on what is called post-release control. We sometimes call that parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. You understand that?
Yes, sir.
And if you are on post-release control and you were violated any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a... Oh, this is parole. Sorry. Thank you, Mary. Let me back up. That was for probation violation. If you're on post-release control and you were violating any of the conditions, the parole authority could return you to prison as punishment. I'm not involved in that part. But the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence, there are other sanctions I could order. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, sir.
You can also suspend your driver's license up to 5 years. Do you understand that?
Yes, sir.
And as I indicated before, any right, title, or interest you have in that property in the forfeiture specification, the contraband, will be forfeited to the state of Ohio. Do you understand that?
Yes, sir.
Now, I just explained to you a few moments ago the possible prison term you face. I did use the word possible because prison's not mandatory in this case. You're eligible for probation with this charge, or what is called community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you will automatically be put on probation? It means I'll consider that if that's what you're requesting. I'll look at all the information presented to the court, then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, sir.
All right, give me 1 second for that. Mr. Watson, at the time of the pretrial in this case, I know it was back in June, you had indicated to the court that there was a warrant out for the defendant from Willoughby for a misdemeanor theft. Familiar with that?
I do, Your Honor.
Is that still?
That was taken care of with the with the felonies that were bound over about a week and a half, 2 weeks ago.
Oh, so it's just recently taken care of?
Correct.
All right, so there's no other charge, or he's not on probation for that or anything like that?
Correct, he's not on
I
probation.
just saw that in my notes and I wanted to...
I believe all of that has been addressed through Willoughby, all that's done, and everything will be with this court now.
Okay, thank you. Now, if you were put on probation in this court or community control sanctions, it could be up to 5 years, and as a judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve time in our Lake County Jail of up to 6 months. Do you understand that?
Yes, sir.
Further, if you are on probation at any point to this court and you violate any of the conditions of your probation, we'll have a hearing here in court to see if you're a probation violator. And if it's determined that you are, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation at that point and send you to prison then. If I did it at that point, again, it could be 6 to 12 months in prison, and that could be consecutive to any other sentence you may be serving at that time or that you're being sentenced to at that time. You understand that?
Yes, sir.
Lastly, when we do proceed to the sentencing hearing, you'll have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, I understand.
All right. Well, do you have any questions at all for the court regarding the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, I do.
You still want to plead guilty?
Yes, Your Honor.
If you had enough time to talk about this case with your lawyer and have him review it all with you, the reports, answer your questions,
Yes, sir.
are you satisfied with his advice and counsel?
Yes, sir.
Has he or anyone else for that matter made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty at this time?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering to plead freely and voluntarily?
Yes, Your Honor.
All right, then any questions for me at this point regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your plea of guilty?
No, Your Honor.
All right, then what we're going to do at this point, the prosecutor here is going to explain for me what she believes the evidence would show at a trial if we had a trial. I want you to listen to her because then I got some questions for you about that, all right?
Yes, sir.
All right, Ms. Contour?
Thank you, Your Honor. The evidence would have shown that on December 21st of 2024 in Lake County, State of Ohio, the defendant was arrested based on a pending warrant. During a search of his person, suspected narcotics were found in the pocket of his pants. Those were sent to the Lake County Crime Lab, confirmed to be amphetamine, a Schedule II controlled substance, the amount being less than the bulk amount.
Thank you. Mr. Hervat, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, you have to say about those facts as she presented them? Are they accurate? Did you do what she said?
Yes, they're accurate.
Very well. Then regarding count one, charging you with aggravated possession of drugs, a felony of the 5th degree, as amended, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a document, 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is, before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Watson, is that accurate?
It is, Your Honor. I did review the written plea of guilty form with my client. I read it. He read along with me, indicated he understood it, and he signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Hervan?
Yes, sir.
So you understand what the document says?
Yes, Your Honor.
Do you have any questions for me about it?
No, Your Honor.
Now, your lawyer said you signed it. Did you, in fact, sign it?
Yes, Your Honor.
And you witnessed that too, Ms. Contour?
I did.
Very well, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all of this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count one as amended, aggravated possession of drugs, a felony of the 5th degree, violation of 292511 of the revised code with the forfeiture specification. I'm going to defer sentencing, order a pre-sentence report and investigation. Drug and alcohol evaluation, and bond will remain revoked. Ms. Conter, is there anything else for the record?
Nothing further, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
All rise.
Okay, friends, I'm back in the chair. Thank you for bearing with me while I went and helped my wife with something. Let's go to Miami-Dade. This is Judge Maria de Jesus Santovina. She wins the Most Complex Name of the Day award. And this is very much the B team, I think, for the holiday. Let's see what's going on.
Ms. Nagy, I'm entering a stay away order requiring you to stay away from the victim, Joanna Salmeron. You cannot have any contact with her. No contact means no contact by any means. And you may return one time to the residence within 48 hours of entry of this order, accompanied by a police officer to retrieve your personal belongings. Do you understand that stay away order?
She does.
Yes. Okay, the hearing is concluded. Next case is Tommy Jose Sevilla Alvarado.
Your Honor, Mr. Sevilla went to felony court yesterday. He received a bond of 2,500 with a hold on a case that he's on felony bond, F2522884.
Your Honor.
Okay.
Morning, Miss.
So released on felony bond in the case.
We're addressing the misdemeanor DV. He has a felony also, which he went to court yesterday on that case. And he received a bond of 2,500 with a felony hold.
Okay, the court finds probable cause. So he has felony hold on the other case.
Right.
We need to put in the case number. Okay. Okay, Mr. Sevilla Alvarado, I'm entering a stay away order requiring you to stay away from the victim in this case, Jennifer Alvarado. You're to have no contact with her. No contact means no contact, so you can't communicate with her by email, text, in person. You can't send her any messages through another person. You may return to the victim's residence one time within 48 hours of entry of this order, accompanied by a police officer to retrieve your personal belongings. Do you understand the stay away order?
Yes.
Okay, the hearing is concluded. Moving on to.
For the bonds, Your Honor?
Okay, so hold on, the bond amount,
For the felony case, but he has a separate bond for this. For the bond amount for the felony case, I believe, what, 2,500, is that right, counsel?
I believe.
So we would just be
Yeah.
asking for bonds in the amount of $500 for the criminal mischief and $1,000 for the battery.
okay, so surrender bond for criminal mischief of how much?
500.
$500 and the battery
1,000.
and $1,000 battery. Now that you're moving on to Lavaris on Beckham.
Oh, you.
Reviewing the rest of it. Court finds probable cause.
And I'm gonna be asking for pretrial services, Judge, no priors, and he is local.
He qualifies.
Yeah.
Pretrial services with an alternate bond of
$1,000.
$1,000. I'm entering stay-away order. Mr. Beckham, requiring you to stay away from the listed victim in this case. Is that Ayatur Marian? What is the name?
Yes, Winter Marion.
Winter Marian. You can have no contact, Winter Marian. No contact means no contact by any means, in person, by telephone, by text. You can't go within 500 feet of Winter Marian. You may return to the victim's residence one time only within 48 hours to retrieve your personal belongings, accompanied by a police officer. Do you understand the terms of that stay-away order?
He does.
Was that a yes?
Yes, ma'am.
I want to hear it, Mr. Beckham.
Sir, I'll be there.
Hearing is concluded. Moving on to next case, Walter Sanchez.
Mr. Sanchez, you have the vote for immigration.
In what?
Español.
What would the interpreter, Judge?
Okay, we need the interpreter. I'm reviewing the arrest affidavit.
Estoy revisando la declaración jurada que sustenta su arresto.
Court finds probable cause for battery.
El tribunal determina que hay suficientes indicios en relación al cargo de agresión con toque o lesiones.
What bond being requested?
$1,000.
¿Qué fianza se me pide?
$1,000 standard bond.
$1,000 fianza estándar.
I'm entering a stay-away order. Mr. Sanchez, requiring you to have no contact with the victim by any means. That includes in person, by telephone, by text. You can't go within 500 feet of Madison Nunez Varela. You may return to the house one time only within 48 hours of the entry of this order to retrieve your personal belongings, accompanied by a police officer. Do you understand the stay-away order, sir?
Señor Sánchez, estoy emitiendo una orden de alejamiento que prevé que usted tenga contacto con la presunta víctima en esta causa, ya sea en persona, por teléfono, por texto, por teléfono, de cualquier manera, y además no puede acercársele a menos de 500 pies de distancia a esa persona, que se llama algo así como Mari Varela, y se le va a permitir volver a la residencia común una sola vez, una vez que quede en libertad de esta detención, en un plazo de 48 horas a partir de ese momento, acompañado por algún policía para recoger sus pertenencias personales allí. ¿Ha entendido la orden de alejamiento?
Sí, sí.
Yes, yes.
Okay. Have present here in the courtroom whom?
Yo soy la esposa de él.
I'm his wife.
And what is it you want to address with the court, ma'am?
Y señora, ¿qué quiere usted decir aquí en esta sala?
Yo voy a pagar la fianza de él para que él pueda
I'll
salir.
post his bond.
Orden de alejamiento que usted le está emitiendo para que él no se
I'm sorry, Judge, the interpreter can barely hear the witness.
Okay. we need you to speak nice and loud to the microphone because the interpreter is somewhere else.
Necesitamos que hable directamente al micrófono en voz alta y clara porque el intérprete se encuentra en algún otro sitio.
Okay, can you put the microphone down for her? Thank you.
Yo soy la esposa de él. Yo voy a pagar la fianza de él para que él pueda salir en libertad y nada más que le den la orden de alejamiento para que él no esté cerca de nosotros.
I am going to post his bond or bail, and I would like the restraining order so that he won't get close to us.
Okay, ma'am, so we have already determined that the standard bond is going to be $1,000 and I have already entered a stay away.
Señora, ya hemos determinado que la fianza estándar son $1,000, es la fianza que se ha impuesto y también dicté ya una orden de alejamiento.
Ok, ¿cuándo se puede pagar la fianza o cómo?
When can it be paid?
Anytime.
I believe that now you can go and
Immigration
bond.
Oh, he is on immigration.
Tengo entendido que ya lo puede pagar, pero él tiene una orden de retención por parte de las autoridades migratorias.
Okay, so the issue is though, ma'am, that there's a hold on this gentleman for ICE. There's an immigration hold.
El problema, señora, es que en relación a ese caballero, inmigración ha pedido que se le retenga.
So understand that even if you paid the bond, they're not going to release him because there's an immigration hold.
Tenga presente que si usted paga la fianza, no lo van a dejar en libertad porque las autoridades migratorias se han pedido que se le retenga.
Okay, the hearing is concluded.
La audiencia ha terminado.
We're moving on to Michigan Floyd.
Mr. Floyd is on felony bond, F25-11951.
Okay, ma'am, the hearing is concluded. You are excused. And the interpreter.
La audiencia, señora, en esta causa de que usted compareció ha terminado, por tanto se puede retirar.
Okay, on Michigan Floyd, I'm reviewing the arrest affidavit.
Judge, I will have a PC argument on this case.
I'm sorry?
I will have a PC argument on this case.
Go ahead.
So Judge, if you look at page 1, there are allegations of assault only. Then on page 2, Mr. Floyd denied the allegations and there is no independently corroborated evidence or facts that would support battery charge. So it is not more likely than not that he had committed battery. As such, would be asked to find no PC.
Your Honor, the victim stated that she had bruises. The officer noted such bruises. I believe what defense counsel is pointing to is just the victim's statement to the officer she was assaulted. Obviously, and in common parlance, assault and battery may be used interchangeably by victims, not officers of the court. The officer's writing what the victim told the officer. Clearly, what she meant by assault was battery, as there were physical observations of battery. Again, that being the bruisings that were on her legs, arms, and lower lip.
And Judge, just to add, the arrest did not happen until many hours after the alleged battery. And it is our position that she inflicted her injuries upon herself.
Court finds probable cause. What is
1,000.
standard bond?
And for pre-child services, Judge.
He's on felony.
I'm sorry?
He's on felony bond.
Okay, so sir, whatever you have to say, you need to say it to your attorney. You might not be helping yourself by saying anything at this point. Standard bond of $1,000, but he is on felony bond in another case.
Are you placing a hold on the case that he's on felony bonds?
Placing a hold on him, yes.
Thank you.
Okay, sir, I'm issuing a stay away order requiring you to stay away from the listed victim in this case. Eva Ramsey, you can have no contact with that person by any means, including by telephone, in person. You can't send an electronic communication or a text. You cannot go within 500 feet of the victim. You may return to the victim's residence one time only within 48 hours, accompanied by a police officer to retrieve your personal belongings. Do you understand the stay away order?
Sir, and, yeah, the judge is asking if you understand the stay away order. Yeah.
Did I? Okay, thank you. Did I stay away order into? Be fast. Okay, next case. Inoya Francis.
Yes, ma'am.
Mr. Francis is a fugitive, also a fugitive from Broward County, has a total cash purge of $704. He also has an open felony F23 16955 alpha.
Okay, so is there a request for felony hold?
Sorry, from the state. Or
Is there a request to hold him? Or you're just letting me know for bond purposes?
Your Honor, it's up to you if you want to hold him or not.
He's a fugitive from where?
From Broward County?
And is it on that felony case?
No,
No,
this
it's
is
a civil
separate.
writ.
Separate. The felony case is a Miami-Dade case. The fugitive is a writ of arrest. It's a cash proof of $704.
From where?
Okay, so for the felony case, is there a,
you can issue a felony hold.
Judge, from
is there a future court hearing for that?
child support writ, it's a civil writ.
Hold on. I need you to speak into the microphone because if not, I cannot hear you, but hold on. I'm hearing it from the state.
So, let's see, no future hearing date at this time, for felony case. For the sheet that we have.
Okay, was he out on bond on that case?
Yes. That's from 2023.
Great, let me hear from the defense counsel.
Yes, Judge, so as to the Broward hold, it's a civil writ, it's not a criminal case. And he does have cash purge on that, so we'd ask you not to address that at all. And with respect to the felony, it's the court's discretion.
Okay, so what's alleged is that he committed this offense that he's here on now while he was out on bond in the felony case. Court finds probable cause. It's not marked off in the stay away order, but I believe the victim is an ex-girlfriend with
They reside.
the defendant has children.
Yes. That's correct.
So he'll be held for the felony case. So then will future court be issued for him to see that judge?
Yes.
Do we set that now?
And then the bond for this misdemeanor case,
Okay, what is the standard bond?
1,000.
1,000?
1,000
The felony duel, standard bond for this case, 1,000. And then I'm entering a stay away order requiring you to stay away from the listed victim in this case, Antonia Gibson. You're to have no contact with her. That includes by any means, in person, by telephone, by text. You can't send her messages through another individual. You cannot come within 500 feet of where she may be. Do they reside together?
Yes.
Okay, so you may return one time to the victim's residence within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal belongings. Do you understand that stay away order?
Ma'am.
Do you understand the stay away order?
Ma'am.
I'm sorry, what is he saying?
Yes, ma'am.
Yes, ma'am. Okay, I just heard the ma'am part. All right, the hearing is concluded. We're moving on to Ernesto.
All right, once again, good morning, everybody. It is Veterans Day. Happy Veterans Day. Welcome to the Courtroom Files Live. Sort of. A little bit of live, a little bit of Memorex today because of the holiday. Not much live going on in the courts, though this feed from Miami-Dade is live. But let's go into the Wayback Machine a little bit. We will go to yesterday. Judge Corey Wiggins in the 84th District in Michigan was doing jail appearances. So let's spend a little time watching that.
4745 OD, we're here for an arraignment. Ma'am, did you have the opportunity to meet with somebody from the defender's office today? Mr. Harrison, or? But she did meet with someone from your staff?
She met with Brian, yes.
Ma'am, I have a complaint that alleges that on or about November 8th, 2025 in the city of Cadillac in Wexford County, it is alleged that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by a fine of not more than $500 and or 93 days in jail with an additional suspension or revocation of your license, vehicle immobilization, community service and rehabilitative programs, along with reimbursements for the costs of prosecution and governmental expenses. Do you understand those charges and the potential penalties? All right. That advice of rights form we mentioned earlier, did you read that form? Talked about your rights to an attorney and your rights to a trial?
No, Your Honor.
All right. So I'm going to go through those rights with you. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make those arrangements. You've been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with permission of the court, to have a trial by jury, and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to be able to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney, and you can test your ability to pay the ordered fees if the court attempts to collect the cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up those rights that we just went through. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days from the date of sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights?
Yes, Your Honor.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one will be appointed to represent you at public expense, but you may be required to repay that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointment of an attorney.
And what is your current source of income?
Social Security.
Court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I do not show any prior history, and the practice scores her at a risk level 0, and a $250 bond was posted over the weekend. Mr. Harrison, any comment regarding bond?
I think the presumptive, the cash bond that's been posted is more than sufficient as far as the bond criteria. None of them seem to apply to her. She doesn't appear to be a risk, a flight risk. It doesn't appear to be a danger to the community at large. Obviously, the court would be within its rights to seek some form of testing, but I'm unaware of the presumptive BAC in this case, so I can't comment on that. I'll leave it to your discretion.
Thank you, Ms. Lawrence.
Thank you. This was a traffic stop that stemmed from crossing the center line and some poor driving. There was a PBT that came back at a 0.133. Given that at this time, the people would just have for random alcohol testing. Thank you.
All right, the court will continue the bond as previously set with the following conditions. Ma'am, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any alcohol, and you'll be subject to random testing. You can go out to the front window where you checked in, get your next court date. You'll have some paperwork to fill out for the public defender's office, and then you'll need to go downstairs to the community corrections office to get signed up for testing. Okay? All right. Thank you. Person at the Wexford County Jail, please state your name.
Ethan Anderson.
I'm sorry. All right, this is case number 254461 SD. Mr. Thomas, you appear on behalf of Mr. Anderson.
Sorry. Thank you, Your Honor. I, Thomas, on behalf of the defendant who is present via Zoom.
All right, and we are here for an arraignment on a bench warrant for, it is alleged that Mr. Anderson, you failed to appear for a random alcohol test as ordered on November 1st and November 2nd, and that you also failed to appear for a drug test as ordered on November 1st and November 2nd. Mr. Anderson, you do have the right to set this matter for a contested hearing where the prosecution would be required to prove the alleged violations, or you can plead to those violations, and I'll turn to Mr. Thomas. How are we moving forward today? Mr. Thomas?
Would you like, Your Honor, it's my understanding that Mr. Anderson intends to plead guilty to the bond violation.
All right. Ms. Lawrence, any objection to that?
No.
Mr. Anderson, is that your intent today, is to plead to the bond violations?
Yes, sir.
All right, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Let me put your hand down. Sir, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
Yes, Your Honor.
Then to the allegations that you failed to appear for a random alcohol test as ordered on November 1st and 2nd, and that you failed to appear for a drug test as ordered on November 1st and 2nd. How do you plead?
Guilty, Your Honor.
In order to accept those pleas, I must have you tell me what it is that makes you guilty. So did you know that you were supposed to appear for testing on November 1st and 2nd?
It was the randomized testing, and I just woke up too late, and that's why I presume myself guilty. It's as charged. I didn't appear.
Okay. So you said you woke up late. Did you check your numbers to see if you were supposed to appear, or did you do that and just not appear?
I woke up late. I checked the numbers, and I realized that I was supposed to appear after testing had already closed on both days.
All right. And you realized that, or you knew that testing was a condition of your bond?
Yes, Your Honor.
Do counsel believe the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
All right. As does the court, I find the defendant guilty of violating his bond conditions for failing to appear for testing on the 1st and 2nd of November. That leaves us what to do with bond, Mr. Thomas?
Thank you, Your Honor. There is no other way to characterize this than a mistake. Mr. Anderson on the weekend was unaware of the testing times on Saturday, the weekend time being different than what they are during the week. And when it comes to the Sunday testing, Mr. Anderson uses a nightstand alarm clock that he sets for his alarms. That, as we know, it does not get automatically updated as the time changed on that weekend. I believe it was the day after or the morning of the time it changed. So due to that hour pushback, Mr. Anderson had missed that test as well. I called this a mistake earlier, not to minimize it or to say that it's to reduce it in any way. I only use that language to say that with mistakes, we hope to learn lessons. And I believe Mr. Anderson has learned his lesson about the importance of the punctuality and showing up for these tests and doing them. As he spent the weekend in jail, he's here today, appearing via Zoom and not here in person as he'd like to be. I will add, Your Honor, to the argument at the end of, I believe, last week, or it was the week before, Mr. Anderson can correct me, but for his job that he is just starting, today's supposed to be his first day, he did have to complete a drug test. I'm not sure if it was with alcohol or if it was just drugs. We did have to complete a test for that employment. So he is not trying to avoid testing in any way. He's not trying to conceal anything. I don't have the results of that test yet. I had asked Mr. Anderson to provide that to me as soon as he gets them. He hasn't received them yet, so I don't have them to present to the court today. But with that in mind, we are asking that the court allow the bond conditions to resume as they originally ordered, or at the court's discretion, because Mr. Anderson can now afford it. If the option for a daily testing using a breathalyzer that he takes home is an option, as before he could not pay for it, now he can, and he would like to use that if possible, instead of the random testing and coming to the court in person. But that's at the court's discretion. I will leave it at that.
Mr. Thomas, am I accurate? We haven't even gotten to a pretrial in this case yet.
Pretrial scheduled for Wednesday, Your Honor.
All right, thank you. Ms. Lawrence?
Thank you, Your Honor. I am going to ask for a remand in this case. Just to remind the court, the underlying operating while intoxicated, the defendant actually flipped his truck over on a curb, which is pretty serious, and the defendant is not even legally allowed to drink yet. Like the court just said, we haven't even gotten to the pretrial yet, and he has had multiple bond violations. It doesn't escape the people's mind that this occurred on Halloween weekend. He decides not to show up for 2 tests. I think given that, it's clear the defendant is not taking this seriously. So the people would ask for a remand. Thank you.
All right, we are here on what equates to our 3rd bond violation. First one was back on October 28th. Defendant was placed on bond October 20th. So this is not his first, might be the first weekend he's required to test, but it wouldn't be his first time going through a weekend of testing and checking. Also, if I'm doing my math correctly, in the fall, we fall back when it comes time to setting clocks. So he would have been early, not late for testing. If it was 10 o'clock, it's now 9 o'clock, so he would have been early. I do find Additionally, that bond was previously set at $250. I've got somebody on a drunk driving charge on his third violations for testing issues. The defendant will be remanded and bond forfeited. Next arraignment, jail. Did you have a question, sir?
Yes, Your Honor. Do I have a cash bond or?
Oh, you're being held without a bond at this point. Thank you.
Thank you, Your Honor.
Thank you. Court calls the people of the state of Michigan versus Samuel Robert Richard Cronkite.
Kind of watch together. Let's get some vibes.
This is case number 254743 SM. We're here for an arraignment. Mr. Cronkite, on the back of your advice of rights form, you did not fill out an email address or a telephone number, but I see there's one on the praxis from when you met with Community Corrections. Is that information accurate?
Yeah.
All right. Did you read this advice of rights form? All right. Do you have any questions for me about those rights? No? Did you have the opportunity to meet with somebody from the defender's office today?
Yeah.
I have a complaint that alleges that on or about November 8th, 2025, in the city of Cadillac of Wexford County, does allege that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. If it happened in a place of confinement, it is possible for consecutive sentencing. Do you understand those charges and the potential penalties? I'm sorry?
Yes.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney? What is your current source of income?
I'm DoorDash.
Court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. So you don't, the bond says 500, but the green sheet says 2,500.
No, I just screwed up and I crossed out the. It's fine.
Counsel, historically, I show in 04 driving the license suspended, 05 an attempt to resist and obstruct, 06 an attempt NSF check, 06 an attempt NS check, 06 driving the license suspended second, 17 operating while visibly impaired, and 20 assault and battery down from a domestic, 20 jostling down from a domestic, 23 disturbing the peace down from a domestic, and 04 an MIP of alcohol, 05 MIP alcohol, 08 malicious destruction of property less than 200, 09 interfering with an electronic communications device and the domestic violence was dismissed, 08 there was a domestic violence, and in 13 a disorderly drunk. Bond was set at $500 over the weekend, which has been posted. Mr. Harrison, any comment regarding bond?
I would have the court observe the bond that's already been posted. He's not a flight risk. He's a member of this community, has been for multiple years. I would make a peremptory request here. It's a little bit difficult because the alleged victim is his 15-year-old son, who's also named Sam Cronkite. That's going to be a little bit cumbersome given the age of the purported victim to police out the no contact order. There's some discussion that his son can go live with his mother, the child's grandmother rather. I don't know how that's gonna work, getting him back and forth to school, X, Y, and Z. Just putting that out there for the court's consideration. This is a difficult family dynamic. At this point, it's hard to determine, for example, who's the aggressor even in this incident. Obviously, we'll learn more as the discovery continues. Thank you.
Thank you, Ms. Lawrence.
Thank you. The defendant's criminal history does pose some concern to the people. This kind of sounds like it's starting to become a pattern. Given that, the people would ask for no contact order with the victim. I do understand it is the defendant's son, although our office has not had direct contact with him at this time, so we would still ask for that no contact order to be put in place. Additionally, although there was not a PBT done, there was some signs based off officer's report that the defendant was highly intoxicated during this incident. So given that, I am going to ask for random alcohol testing as well. I will bond up to the discretion of the court. Thank you.
Thank you. All right, the court will continue the bond as previously set with the following conditions. Defendant appears ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. Until I know more, I am going to order that there be a no contact with the victim in this case, or the alleged victim in this case. Additionally, Mr. Cronkite, you are not to purchase or possess any firearms or weapons, not acting any threatening, intimidating, or harassing behavior, not to consume alcohol, and you'll be subject to random testing. You can go out to the front window where you checked in, get your next court date. You'll have some paperwork for the defender's office, and then go downstairs and get signed up for testing. All right, thank you.
Thank you.
Person at the Wexford County Jail, please state your name.
All right, we'll look at coming back to Judge Wiggins perhaps in a little while. Let's go back to Lake County and Judge Collada. Again, this is in the Memorex, the Wayback Machine from yesterday. He has another hearing we'll take a look at.
Good afternoon. We are here in case 25 CR 1196, State of Ohio versus Adam Kane. Here for a pretrial. Mr. Kane is here. He's with his attorney, Mr. William Watson. State of Ohio is present, represented by Assistant County Prosecutor Amy Alessi. All right, Ms. Alessi, what's this all about?
Back on April 28th of this year, Gregory Brown, the victim in this case, owned a business over off of Euclid Ave. When he came into work, he noticed that a trailer that had been parked adjacent to the business, which had a truck on top of the trailer, had been stolen from his business, at which time he reported it to the police department. He had surveillance video at his business, and he was able to see a blue GMC truck back into the business around 4 a.m. and a male exit, hook up the trailer with the vehicle, the truck that was on top of it, and drive away. When police began investigating, they had learned that the trailer was found in Garfield Heights. The trailer and the truck, I'm sorry, were found in Garfield Heights. With the trailer, the person who later we learned was the defendant had left a note on it asking that the person's residence that it was out front of not to tow the trailer, and he left a phone number on that note. And through further investigation, working through OLEG, Facebook records, flock records, they were able to identify the defendant as a potential suspect in the case. Later, they were able to speak with a friend of the defendant's girlfriend, and get a good cell phone number for him. Cell phone records put him in the area at the time of the theft. Eventually, they do arrest and speak with him. The defendant said he was an alcoholic and a drug user. Doesn't specifically remember coming to Wycliffe on this day, but admitted it was possible that he came to Wycliffe to steal the truck and trailer due to him being intoxicated.
Thank you. Provided all discovery?
Yes, all discovery has been provided.
And is the state prepared to make an offer today?
Yes, Your Honor. The state is offering count 2, grand theft of a motor vehicle, a felony of the 4th degree, and count 5, receiving stolen property, a felony of the 5th degree. Regarding sentencing, the state would reserve the right to recommend any available sentence.
Thank you. Does the defendant have any history?
Yes, Your Honor. The defendant has a lengthy criminal history, including 5 prior prison numbers. More recently, at the time he committed this offense, he was on community control sanctions through Summit County for possession of a fentanyl-related compound, and also since just prior to, well, the date of this offense, in March of this year, he had been indicted in Summit County on an aggravated possession of drugs F5. In August of this year, he was sentenced to community control sanctions in that case.
So he was on probation at the time through Summit County?
He was.
Okay. All right, Mr. Watson, you got discovery, received it? Any issues with that?
Thank you, Your Honor. Please, the court. Yes, I do have discovery. No issues at all. And I will be discussing this matter with my client. I'm sure we'll have an answer well before the scheduled trial date.
Okay. Any suppression issues or any other issues that will require an evidentiary hearing?
At this time, I'm almost positive no. I will review with my client, but I don't anticipate any pretrial motions like that, Your Honor.
All right, thank you. All right, Mr. Kane, you have been released on an own recognizance bond. That means you have to appear at all future court dates. I need to advise you that if you fail to appear at any future court dates, that's a separate felony, separate and apart from whatever you've been charged with, where you can be sent to prison for anywhere from 6 to 18 months in addition to whatever would happen here. So it's obviously important you show up at all future court dates.
Absolutely.
I need to advise you that as of right now, your next court date is the trial, which is scheduled for January 13th, 2026 at 8:30 in the morning. And it'll be right in here. So that's the next scheduled court date. If this is going to resolve by some way of a plea, and I don't know that, you don't know that at this point, I know you need to talk to your lawyer, so I'm not looking for any answer, but if that's going to happen, it will happen before the trial date.
Okay.
So you and your lawyer are going to talk, and if you come to the decision that you want to enter a plea, your lawyer is going to contact the court, and we will schedule a new date, a different day earlier.
Okay.
So if that were to happen, you need to make sure you find out what that date is.
Absolutely.
Your lawyer will send you some notice or some message, but if you don't hear from him, or for whatever reason you don't learn from it, it's ultimately your responsibility, not his. So reach out to him, you can reach out to the court, you can go online, there's plenty of ways to find out when it is. But it will be before that day.
Right.
The trial is set for January 13th, which means that the court needs to know by December 30th whether you're going to accept the state's offer or not. So it's still some time there.
Okay.
You can let us know before that if you want, but we need to know by at least December 30th if you're going to enter some type of plea. If we don't hear from you by that day, then the court won't accept any plea except to the indictment. All right? All right, I think that covers everything. Ms. Alessi, anything else for the state?
No, Your Honor. Thank you.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
Thank you.
Okay, friends, let's go back to Oakland County. Magistrate Cody Ellwanger. This is holiday arraignments that he is doing there, so we're back to today's proceedings now.
Okay.
They blanked out.
Now calling prosecutor order number 25-13162, the People versus Stephen Anthony Bard Jr. This is the date and time set for arraignment. Counsel, your appearance.
Attorney Monique Sanford, P62315, on behalf of Mr. Bard, waive formal reading, client stands mute.
All right, the court will waive formal reading and answer a plea of not guilty on behalf of Mr. Bard. Mr. Bard, did you fill out a request for court-appointed attorney form?
No. Fill out any paperwork.
Are you requesting a court-appointed attorney moving forward?
Yeah, well, if this case is even getting taken serious, yeah.
Sir, for the purposes of this proceeding, it is going to be set for a pretrial date. So if you want counsel to represent you at that pretrial, you will need to request court-appointed counsel.
Okay, well, I requested, and if anything changed, what should I do? Report it, or if I get a lawyer? What should I do?
Well, so this is your, and this is why I hate being cut off. This is your arraignment. So you're being arraigned on the charge of domestic violence. Your next court date is going to be a pretrial. You're going to want to have counsel at that next proceeding. And then you can discuss the case with that attorney and strategize how you want to proceed. But the case isn't going anywhere between now and the pretrial.
Okay.
Okay.
Mr. Bard, are you currently employed?
Yeah, I'm self-employed. I have my own landscaping company.
All right. Approximately how much do you make per month on average, would you say?
Doesn't
have to be exact. Give me an estimate.
It varies, probably like well, last month I only made $3,000 profit, and the rest I had to pay the workers.
Okay. And so do you have any fixed expenses, rent, car payment, anything like that?
Yeah, car payment, rent.
All right. So out of the $3,000 from last month, after your fixed expenses, how much did you have left? About
$1,800.
All right. Then based on your representations, I do find that you qualify for court-appointed counsel. So I will appoint an attorney for you moving forward. If you decide to retain your own attorney, you have every right to do that. Okay. But at least this way you will have an attorney moving forward. Counsel, as it relates to bond, what would you like to state on behalf of Mr. Bard?
Your Honor, it's my understanding he is self-employed with a tree and landscaping company. He does have a GED. He's 29 years old. He does have a residence that he can stay in Pontiac 29 South Edith, Pontiac, Michigan. I would ask that he would have a one-time police escort so that he can get his basic belongings, and that the court consider granting him a personal bond in this case.
Thank you, counsel. Detective, I see that Mr. Bard has, looks like a couple warrants outstanding right now. Do you know where those warrants are from? What jurisdictions?
I think one's out of Waterford, but you can say the rest if you know.
So it should only be Waterford. I was at Havenwick and I had missed my court date. So when I got out of Havenwick, I was supposed to go yesterday, but all this happened. Yesterday, they told me to come after 1:30 to get a rain. It was none driving without my ID, but the police had my ID at the time. So the case was getting through out anyways. It's just I missed it because I was at Haven.
And I think there was a couple of show cause hearing warrants, but I don't recall where those were out of, Your Honor.
Thank you. Obviously, I mean, I can understand the warrants to a certain extent, but there are a few outstanding bench warrants, and I do see a few criminal convictions. And I after hearing the swear to, I do have concerns about the safety of the alleged victim as well. And I do not believe that a personal bond is warranted in light of the convictions and the facts that I heard here. I'm going to set bond in the amount of $25,000 cash or surety. I will allow a 10% provision. And I'm also ordering the following conditions. You are to have no contact with Taisha, LaShawn, Glenn. You shall not return to 1666 Bloomfield Place Drive except for one time with a police officer to gather your belongings. After that, you will have to reside elsewhere so long as this case is pending or unless ordered otherwise. You will personally appear for any and all future court proceedings. You will not leave the state of Michigan without permission of the court. You will immediately notify the court in writing of any change to your address or telephone number. You shall not possess any firearms or other dangerous weapons. You are going to be under pretrial services supervision, which means if you post bond, you must contact pretrial services within 24 hours of your release. You must obtain a GPS tether prior to your release. And lastly, no new criminal offenses or activity. So Mr. Barr, do you understand the terms and conditions of your bond?
Yeah, so you put me on GPS tether for a woman that I have 20 reports of lying reports. Why would you put me on GPS for a case that's not true?
Because I have concerns. Mr. Bard, this is, okay, Mr. Bard,
it's 20 reports every county that I never caught a case pertaining to her line. 20 reports all over Michigan that I never caught a case. You put me on GPS for words, no evidence, word, GPS, you put me on GPS. You already make me pay a bond.
Mr. Bard, so I already authorized the complaint and warrant based on the facts that I heard. You're going to have your day in court, okay? You will have your day to go to trial and make your case. I'm saying as of right now, I have concerns over the safety of Miss Glenn.
How you got concerned over the safety of Miss Glenn? And you don't know her. You only can go over reports. She got a lengthy report.
All right, Mr. Bard, I'm not going to change my mind. I think based on your prior criminal convictions, your outstanding bench warrants, and the facts that have been alleged here, I think that my bond is actually pretty reasonable. I don't think I'm abusing my discretion, but if you'll have the opportunity to address bond at your next hearing, if you're not able to post.
I'm just speaking about the GPS. That's all. GPS.
The GPS is only going to enforce the fact that you are not to go back to 1666 Bloomfield Place Drive. It's not going to keep you from working. It's not going to do anything else other than ensure that you do not go back to that residence. So I don't have your next court date in front of me, Mr. Bard. If you do post bond, make sure you contact the 48th District Court, find out when your court date is, and make sure you abide by all of your bond conditions. So that is all for today. I wish you the best of luck.
Thank you, Your Honor.
Thank you, Detective.
All right, once again, friends, good morning. Happy Veterans Day. Glad to have you here at the Courtroom Files live, at least mostly live. We do have some Memorex today, as it is Veterans Day. A lot of the courts are quiet, but the magistrate courts are running. We're going to go to a different one here in a second, but before we do, I wanted to call your attention to our new Discord server. There's a link to it in the pinned chat. I encourage all of you to take a moment and sign up for that. The biggest thing is for alerts. As long as you opt into alerts when you sign into the server for the first time, you'll get an alert every time we go live and every time we post. Which you won't get right now from YouTube. YouTube is playing a lot of games with notifications, and you're not getting alerts from your favorite creators. So if you want to have alerts from us, do sign up for that server. It doesn't cost a dime, but that's one of the biggest things it gives you. But we have a lot more things that will be going on there as well, as you'll see when you get in there. One of the biggest things that we're going to have, hopefully starting next week, but things are a little bit in flux at the moment here at the TCF bunker, is the addition of an after show. We'll have 15 or 20 minutes after each live show here at TCF, and that will be on the Discord servers where that will be hosted. So if you want to be ready for that when that comes online, be sure to, again, join us over on Discord. So let's stay in Michigan, but we'll go over to 14B in Ypsilanti. This is Magistrate Hillary Braley. And this is today. This is live, so let's see what's going on there.
Good morning. 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Hello with the jail. Can I have your name, please?
India Tulu.
Okay, I need you to speak up, please.
India Tulu.
You? Are you able to hear her? Now calling case number 25F55774. This is the people of the state of Michigan versus India Charisma Amaris Tootle. Appearances for the record, please.
Yes, Your Honor. Good morning. Katie Rizmersky for the people.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender. I'm requesting appointment to represent Ms. Tootle.
Thank you. Did you want to address the plea?
Yes, Your Honor. I have reviewed the complaint with Ms. Tootle, so we would waive the formal reading and stand mute at this time.
Okay, thank you. Ms. Tootle, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No, Your Honor.
Okay, thank you. Because this charge is considered a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Any questions about that?
No.
Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be November 20th, 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. 14A1 is the courthouse that's located basically above where you are right now at the jail. All right. Okay. Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So do the attorneys want to address bond, please?
Your Honor, is the court in receipt of the people's request on the bond form?
Yes.
I think that request from a different APA was for a $30,000 cash surety. I certainly understand that that is perhaps a larger request than maybe we frequently see in retail fraud cases. I will indicate that the justification for that on the form tracks with me. There's a prior retail fraud first conviction. In this particular incident, there was over $2,000 worth of goods that were stolen. And in addition, it appears that the defendant here is a suspect in 6 other Lululemon retail fraud investigations. So that's the basis for the request, Your Honor, and I don't really feel I have anything to add to that unless the court has any questions.
Thank you. Attorney Yagi?
Thank you. We are requesting a personal bond at this time for the following reasons. So first of all, Ms. Tootle is working and in school. She works at the Tropical Smoothie, and she's also in school studying culinary arts. She is relied upon to help support her family. Also, she has a mom who has health issues and surgery coming up, and a little sister who rely on her to help pay their bills. I understand the people's representation to the court. However, at this time, I only saw, let me see here. I don't believe I only saw one hold for a traffic case for Ms. Tootle. So I think it's a little premature for the people to say she has all these other allegations against her if they aren't pending charges. At this time, I'm not aware of the pending charges, and I'm going to double check her iChat to see. I didn't see. Let me see here. Oh, it looks like there's a pending charge that I do see out of Novi, I believe. But all of that is to say, I don't believe, given that this allegation is from June, and I think that alone should be reason for the court to grant Ms. Tootle a personal bond, as there's been no indication that she's fled since then. She's obviously was arrested here in the county. Her family's here in the county. In terms of risk to the community, I think there's no reason for the court to depart from the standard conditions, which would be no going to any Lululemon store. And there's no reason to believe that Ms. Tootle would violate that bond condition. As we discussed, she understands she's facing very serious consequences if she even goes near a Lululemon store, if she is able to be released in bond in this case. So I think that would provide the adequate assurance to protect the Lululemon stores in these matters. So with that, we would request a personal bond with the standard conditions.
All right, Ms. Tootle, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to go to any Lululemon location anywhere. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being that probable cause conference on November 20th. Any questions about the bond conditions?
No, Your Honor.
These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court is going to set a $30,000 personal recognizance bond. So what that means is you are not posting anything to get out today. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, your bond, a bench warrant can issue for your arrest. Your bond can be revoked entirely. At a minimum, it's going to start at the people's request for $30,000. Any questions about anything I just said?
No, Your Honor.
Okay, thank you. Anything else from counsel?
No, thank you, Judge.
No, thank you, Your Honor.
Thank you. Magistrate Attorney Raspersky, but thank you for the promotion. All right. You are free to go to the door and tell the jail that you're finished. Your hearing is.
Okay, thank you. Have a good day.
Hello, can I have your name, please?
Chantrell Stevens.
Okay, say that again.
Chantrell Stevens.
Stevens. I do not have you on my. Yeah, we don't have the paperwork for you. You're not being seen today.
Your Honor, if I could at least indicate to the court, I reviewed that case and denied authorizing charges. So I'm, yes, surprised that that has not been processed to that end yet.
Can you have the court officer or the go to the door and get one of the officers, please?
Excuse me. The judge wants you. He's coming, man.
Good morning, Your Honor.
Hi, so I'm being told that the charges for Chantrell Stevens were denied.
Okay.
So.
All right.
Being processed so she can be released?
Okay.
Okay. Thank you.
Sounds good. Thank you.
Thank you so much, Your Honor.
Thank you all. Thank you.
Y'all have a good day.
Thanks, Your
Hello, can I have your name, please?
Andre Mitchell.
Thank you. Now calling case number 20FB1693. This is the people of the state of Michigan versus Kim Calandra Mitchell. Can I have appearances for the record, please?
Yes, Your Honor. Katie Rosmersky for the people.
And Laura Yagi, Assistant Public Defender, requesting appointment with and on behalf of Ms. Mitchell.
Great, thank you. And Ms. Yagi, or Attorney Yagi, excuse me, did you want to address the plea?
Yes, thank you. We have reviewed the charge, so we would waive formal reading and stand mute at this time.
Ms. Mitchell, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No.
Because this charge is considered a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime has been committed and that probable cause exists to believe that you committed the crime. Basically, it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that the case is strong enough, then it will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Excuse me. Do you have any questions about any of that?
No.
Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be November 20th, 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. So 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So the attorneys want to address bond, please.
Yes, Your Honor, thank you. Is the court in receipt of a bond form? I did not see one in our file.
I don't have.
Okay. It appears, based on my minimal opportunity to review the case, that this stems from an incident that spanned a time period of about, January to April of 2020. So nigh on to almost 6 years ago. It was charged fairly soon thereafter, looks like maybe June 20th. A quick review of criminal history information in our file leads me to the conclusion that there is no prior or in the intervening period of time charges, convictions, anything like that. Judge, I think I'd be hard pressed to ask for anything more than a PR with perhaps a cash as a backup in light of it being a felony charge. And certainly would request no contact and no go-to. It looks like our victim is listed as a Kelly Thomas, who is either the owner or manager or operator of that Look Insurance Company. I could try pretty quickly to see if I can find the location of the Look Insurance Company if that's not readily available to Your Honor. And I think really those would be my only requests in addition to all the standard bond conditions. Thank you.
Attorney Yagi.
Thank you. I won't go into too much detail. Obviously, we would join in that request for personal bond or the recommendation for personal bond. Ms. Mitchell is gainfully employed. And just so the court's aware, she's employed at a completely different place than the place that's listed on this complaint from, over 5 years ago. So I did discuss with her that there would be a no contact. She understands that. She's completely fine with that. So with that, we would ask for personal bond with the standard conditions.
Ms. Mitchell, at this time, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Kelly Thomas. Court says no contact. What the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. You are not to go to the location of Look Insurance. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being that November 20th probable cause conference. Any questions about the conditions?
No.
Okay. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $5,000 personal recognizance bond. So what that means is you are not required to post anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, then a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $5,000. Any questions about anything I just said?
No.
Right. Anything else from counsel?
No, thank you, Your Honor.
No, thank you.
Okay, thank you. Then, Ms. Mitchell, you are free to go to the door and tell the jail that you are finished. Your hearing is concluded.
Okay, thank you.
Hello, can I have your name, please?
Yes, ma'am. Adrian Ryan.
Hi. Now calling case number 25F21746. This is the people of the state of Michigan versus Adrian Joshua Bryan. Appearances for the record, please.
Yes, Your Honor, Katie Rosmersky for the people.
Laura Yagi, Assistant Public Defender, requesting appointment with and on behalf of Mr. Bryan.
Thank you, Attorney Yagi. And can you address the plea?
Yes, we would waive the formal reading of the charge and stand mute at this time.
Bryan, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No, ma'am.
So because this charge is considered a felony, you have the right in this matter to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Any questions about that?
No, ma'am.
Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be November 20th, 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So can the attorneys address bond, please?
Yes, Your Honor, thank you. Again, in light of an absence of a criminal history and taking into consideration the nature of the charge, I see no need personally for anything more than a personal recognizance bond. Again, I would recommend perhaps a cash backup in light of it being a felony. I believe that no contact has been requested on the bond form that was submitted, and that's no contact with who I believe to be the victims in this matter, and we agree with that request as well. Thank you.
Thank you. Attorney Yagi?
Thank you, Your Honor. We would request a personal bond as well. Mr. Bryan is gainfully employed, and actually it's his third day at his new job, and he's really hoping to be able to go back to work, to be able to keep it, to support his partner and his family. And I won't go too much more, but we'd request a personal bond with the standard conditions. I did discuss with him that he would not be allowed to have contact with the individual involved.
Thank you. At this time, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Anastasia Gibbs or Jacqueline Page. When the court says no contact, what the court means is no in-person contact, no contact through mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being the probable cause conference on November 20th. Do you understand all of the bond conditions?
Yes, ma'am.
Okay. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. They have probable cause to believe that you have violated one of these conditions. They can arrest you on the spot. and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $3,000 personal recognizance bond. So what that means is you are not required to pay anything to get out today. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, then a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $3,000. Any questions about anything I just said?
Yes, ma'am. Just for my own personal record, I'll be sent this information regarding the date and times and whatnot as well.
Yes, I believe you should receive paperwork before you leave the jail. All right. You can also reach out to the public defender's office. You can also reach out to the 14A1 district court.
Okay.
If for some reason you don't get the paperwork. So, all right.
Yes, ma'am. Thank you.
Okay, then you are free to, well, actually, wait, to the attorneys, was there anything else?
No, thank you.
No, thank you, Your Honor.
Thank you. Then, Mr. Bryan, you are free to go to the door and tell the jail that you're finished.
Yes, ma'am.
All right, let's step back into the Wayback Machine again. We'll go back to Judge Corey Wiggins from yesterday and pick up pretty much where we left off there.
Bill, what is your name?
Michael Arthur Borth.
This is case number 254742 SD. The people of the state of Michigan versus Michael Arthur Porth. Sir, you met with somebody from Community Corrections Day and gave them some contact information. Is that information accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the defender's office today?
I did, sir.
I have a complaint that alleges that on or about November 8th, 2025, in the city of Cadillac of Wexford County, it is alleged that you committed the offense of operating while intoxicated as a second offender. That is a misdemeanor punishable by $200 to $1,000 and/or 5 days to 1 year in jail, or 30 to 90 days of community service, or both rehabilitative programs, vehicle mobilization, and reimbursement for the cost of prosecution. Do you understand those charges and the potential penalties?
Yes, sir.
Did you read and sign an advice of rights form at the jail, talked about your rights to an attorney and your rights to a trial?
I think I did. I'm pretty sure.
Do you remember doing that, or you just think you did?
Yes, I did.
Did you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. If you could not afford one would be appointed to represent you at public expense. You may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Just the public defender for now.
What is your current source of income?
I have 2 jobs, Ross Exterior. I work full-time there, and part-time at the Pleasant Plains Township Fire Department.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf. We'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show in 19 a driving while license suspended, 19 an operating while intoxicated, 19 another driving while license suspended, 18 a driving while license suspended, 16 an MIP, 16 no license, another 16 no license. And then his CCH gets a little complicated here because it shows there was a conviction. I'm sorry, it shows that he served time for a child abuse third, but it also shows it was dismissed. So any comment regarding bond, Mr. Harrison?
No, in addition to that, Your Honor, we believe that he is still subject to parole requirements imposed by the state of Arkansas. So we're a little bit concerned because we don't know if there's a hold there or not. He's been supervised locally by Mr. Van Admel. I would like, obviously, if that's the case and he's going to be sitting dead time, I would like to see him get released based on this charge, any of the court's concerns can be easily remedied through testing requirements and whatnot. There's no need to hold him if they don't already have a hold on him.
So I saw, it doesn't show, or maybe I didn't get an out-of-state lien, but I do show that there was a transfer with the interstate compact and that he's set to expire December 27th of 2030, and that's for a manslaughter with a motor vehicle. Is that your understanding?
Negligent homicide, yeah, that's my understanding.
All right. Ms. Lawrence, any comment regarding bond?
Yes, thank you. I do not have a police report yet, so I'm pretty limited on my information. I do know this was a traffic stop because the defendant had a defective taillight, and he was also swerving pretty badly, nearly hitting some parked vehicles along Mitchell Street, excuse me. There was a PPT done in this case, and that came back at 135. Given this is the defendant's second drunk driving, I am going to ask for daily alcohol testing. Thank you.
Thank you. I do find that the defendant is a threat to the community. Such a monetary bond is appropriate. Sir, as a condition of your bond, you are to appear as ordered, to keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume alcohol. I believe that's appropriate given that this is allegedly a second drunk driving, and that you'll be subject to daily testing for that. I'm also going to order that you not consume any drugs, and you'll be subject to random testing. That includes recreational marijuana. Because this is a second drunk driving and the fact that the defendant appears to be on parole for a homicide with a motor vehicle, bond will be set at $25,000 cash surety. Next arraignment, Joe.
While we wait for Judge Wiggins' next contestant to show up, I want to point out sidebar tonight at 8 p.m. Eastern, 5 p.m. Pacific. I just a little bit ago posted a link to that in the chat, so be sure to go over there, set an alert for yourself, or even better, just go join Discord, and then you'll always get alerts. But tonight we're going to be discussing digital evidence, so that should be fun. Because, yeah, it's like a big part of everything now. Everybody's got videos. There's people posting stuff all over online, and it's a big piece of court now. So be sure to check us out tonight on Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Looks like our next contestant is all racked up and ready to go.
All right, this is case number 254738 SM, the people of the state of Michigan versus David Scott Reitenberg. Sir, you met with somebody from Community Corrections and gave them a mailing address, email, and telephone number. Is that information accurate?
Yes.
Did you have the opportunity to meet with somebody from the Public Defender's Office today?
I did.
I have a complaint that alleges that on or about November 9th, 2025 in Cedar Creek Township of Wexford County, it is alleged that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Yes, sir.
Did you read and sign an advice of rights form there at the jail, talk about your rights to an attorney and your rights to a trial?
Yes.
Do you understand those rights?
Yes.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Sir, today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointment of an attorney.
What is your current source of income?
I don't have one.
The court will make a referral to the Public Defender's Office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 24 an attempted interference with electronic communications and an attempted domestic violence arising out of the same transaction. The Praxis scores him at a risk level 5, so medium risk. Any comment regarding bond, Mr. Harrison?
Well, Your Honor, I was surprised to see a praxis of that magnitude from Mr. Reidenberg. He did acknowledge when I met with him this morning that he is a child support warrant out of Traverse City. As far as I can tell, there was also a failure to appear for a financial review.
Correct.
In this court, I believe, and that's all that came up initially. So I understand the way the praxis scores. I understand that this score looks a little bit worse than I think the reality of the situation actually is. I don't think it's a flight risk. Despite the failure to appear for a financial review, for me, treat that otherwise. It's just my opinion. I think it's a good candidate, PR or a nominal cash bond. I would have you set some sort of bond here because of the situation with Traverse City. I don't know if they're going to come and get him, if they're holding him right now or anything like that, so that appropriate credit can be doled out when all is said and done.
Thank you, Ms. Lawrence.
Thank you, Your Honor. The people would just ask for a no contact order with the victim at this time.
Mr. Rittenberg, how do you support yourself without being unemployed?
I do have food stamps, and whenever I do go up to Traverse City, I'm planning on trying to get into the homeless shelter up there if I can.
All right. If I release you, is there anything that's going to stop you from coming back to court?
No, sir. If I get into the homeless shelter on up there, I would talk to the people to see what they can do to help me to make it to court on time, or figure out a way to show myself in front of you.
All right. Well, sir, I am going to release you on your own personal recognizance, which is your promise to come back to court with the following conditions: that you appear as ordered, not leave the state without permission, and commit no new crimes. I'm also going to order that you not have any contact with Ariel Wisniewski, that you not purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. Do you understand those bond conditions?
Yes, sir.
No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your own behalf. If you are found to be in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, sir. I don't have her on Facebook, phone number, or any of that.
All right. Now, on your other case, the case that you were here for last year, you currently owe the court $772. Are you able to get set up on any type of payment plan at all for that?
I'm currently I had a job interview on Friday, and I'm waiting to hear back from them. And if so, one of my paychecks will be going directly to you guys.
All right. So what I'm going to do is I'm going to reset this then for a review hearing in 3 months. All right. So before you leave the jail today, you'll be getting your next court date for your new case, and you'll be getting a court date for that financial review hearing. All right.
Yes, sir.
All right. And also, if you find out where you're going to land and get a new mailing address, let us know that. Okay.
Right. If I'm in Traverse City, sir, the mailing address will be 222.
Well, if you
the mail should be able to be sent to.
All right. Well, if you end up going to Traverse City, let us know that, and we'll start sending your mail there. All right.
Yes, sir.
All right. Thank you. Next to Raymond Jail.
Let's take a break from here. Let's go back live. Miami-Dade. See what's going on there.
You get to them. I would just request that can I stay muted, turn off my video until the felony docket?
Okay, so I addressed what you were here for on this case, which was a stay away order.
Yes, ma'am, that's correct.
And you're coming back on the felony calendar.
Yes, ma'am, for Joel Sanudo, another a target
Okay,
arrest.
see you in a bit.
All right, thank you, Your Honor.
Next case is Rafael Morales.
With the assistance of the Spanish interpreter for Mr. Morales, please.
Okay, Spanish interpreter.
Listen.
I'm reviewing the arrest affidavit.
Estoy revisando la declaración jurada de su arresto.
Would be asking for TAP if he qualifies you.
Pedimos el programa alternativo si él califica.
Your Honor, the defendant has extensive criminal priors, therefore not eligible for TAP.
Okay, he's not eligible for TAP. The court finds probable cause on counts 1, 2, and 3. What is the bond for each count?
Stated bond for the
No califica para el programa. El tribunal determina que hay suficientes indicios de criminalidad en relación al cargos 1, 2 y 3. ¿Cuál es la fianza?
Standard bond count 1 is what?
500.
Count-
And 150 for each of the other two counts.
Count 2, 150, and count 3, 150.
Yes, Your Honor.
La fianza estándar en el primer cargo son $500, en el segundo cargo 150 y en el tercer cargo 150.
That was straight bond, Your Honor? I'm sorry? Straight bond. 500 count 1, 150 count 2, 150 count 3. Thank you.
Señor, esto fue fianza sin más. Sí, 500 en el primer cargo, 150 en el segundo y 150 en el tercero.
Okay, the bond amounts have been set. The hearing is concluded. We're moving
Se ha
on.
fijado el monto de la fianza, la audiencia ha culminado.
Harold Radcliffe.
And Judge, Mr. Radcliffe is being brought. He's not present.
Okay, good afternoon, sir. I'm reviewing the arrest affidavit in your case.
And I do have a PC argument as to this case.
Go ahead.
So would be asking the court to find no PC as to each count. With respect to count 1, there is nothing that supports the fact that he was intoxicated or 2 drank alcohol. Nothing indicates that his normal faculties were impaired. As well as for disorderly elements for both cases, there is just not enough. He screamed, he yelled, but for disorderly conduct and disorderly intoxication, they have to be more than screaming and yelling. It has to endanger public, or the crowd has to be such that to impede the police work. There are no allegations recently of the.
Your Honor, if I may, the A form specifically said that the defendant was causing a scene and preventing the flow of operations at the entrance, which.
And this is not enough.
Okay, hold on. Let her finish her argument.
My apologies.
Which is a disruption to the public and a disruption to the security of the location. And the defendant had an odor of alcohol emanated from his person. which is probable cause for intoxication.
And Your Honor, just to point out, for disorderly intoxication has to be more than just having consumed alcohol. It has to be to the extent that normal faculties are impaired, similar to that of intoxication definition that comes out of a DUI statute.
Your Honor, for disorderly intoxication, a disturbance to the public is enough to give probable cause.
Well, for disorderly conduct, maybe intoxication has to be either he had consumed alcohol in public place or he was intoxicated such that his normal faculties were impaired, similar to that of a DUI definition.
I would argue that his behavior and disruption to the public combined with the odor of alcohol emanating from the person is probable cause for both the disorderly conduct and disorderly intoxication.
Is disorderly conduct, breach of the peace, duplicative of elements of disorderly intoxication or included within those?
No, Your Honor, because you have elements that aren't common in that.
So, Your Honor, the disorderly element as to each charge is essentially the same type of conduct. The difference is one is with intoxication and the other one is just acting disorderly without being intoxicated.
What is the bond for each?
150 each.
Okay, you have the do you have the definition or the elements for the disorderly intoxication where it says how intoxicated someone
Well,
needs to be?
so this is it for the statute, right? No person in the state shall be intoxicated and endanger the safety of another person or property, and no person in the state shall be intoxicated or drink any alcoholic beverage in a public place or or upon any public conveyance and cause public disturbance. Here, the person was intoxicated and endangering the safety of the people at this location. I would point out that this was preventing flow in front of the security magnometers here at the Richard E. Gersing building. That obviously can lead to public safety concerns if they're doing that right by where the security is. And that coupled with the intoxication, at least the odor of alcohol that was present on his breath is definitely enough for probable cause. We're not, this is not a hearing for proof beyond a reasonable doubt. Obviously, this is just a lower bar.
Right. What counsel is arguing is that it doesn't meet the definition of disorderly intoxication, which includes some numeric.
But that's nowhere in the statute.
Okay, so that's why I asked you what the elements were. So then let me ask the defense counsel, where do you get that figure from? If it's not in the definition of disorderly intoxication?
I get it from the standard Florida jury instructions, Judge. The term intoxication is defined similar to that in the DUI statute. It has to be more than mere consumption of alcohol.
The jury instructions are relevant when we're, again, trying to look at this beyond a reasonable doubt. But here we're looking at the statute for purposes of probable cause.
Okay, court finds probable cause. Does this gentleman have priors?
Yes, he has open cases as well.
What are those?
Okay, so he has two open cases, 3 open charges. One of which is a resisting without violence, and the other is a battery and a resisting without violence. Those are set for trial each in November 17th and December 1st. He has a prior petty larceny conviction from 1991 and a 2025 withhold to disorderly intoxication from from conviction from 2025. The case was from 2024.
Okay, court probable for both charges, the bond amounts, the standard ones, or what for each charge?
150.
150 each.
Okay, so probable cause is found for counts 1 and 2. Bond set at the standard bond. 150 for count 1 and $150 for count 2. Okay, your hearing is concluded. We're moving on to the next case. Jason E. Lehman.
He refused, Corey, on a reset for tomorrow.
So number 24, Lehman refused.
Yes.
Thank you. I'm sorry, that was number 24 for refused officer, right? Okay.
Jason E. Lehman.
Got it. Thank you.
Next case is Francisco Serrano.
Present, Spanish or English? English?
We need the interpreter or no?
No, Judge, English is fine.
Reviewing the arrest affidavit. Court finds probable cause for trespass. The warning. This was the prior one?
And Judge, would be asking for a lower bond because Mr.
Okay, hold on. Lehman. Which? Did I put them on? Is 44? This one's. Yeah, so you call this one? No, we did, and NBC reset tomorrow. Oh, this is reset as well.
Gotcha. Defense counsel, do you have his priors there?
Yes, I do.
Okay. Do you want to ask him about adjudication CTS for this case?
I'm sorry?
Adjudication credit for time served for this case. You want to talk to him about that for a minute?
This is what you're offering?
Okay.
Sorry.
I'm sorry.
Going back to Francisco Serrano.
And Your Honor already found probable cause. I was asking defense counsel for an offer if he'd like to take of adjudication credit for time served.
I mean, if Mr. Serrano wishes to waive the requirement that the information is filed, then he's willing to accept it.
Okay.
So, Judge, can you call a claim?
Yes.
Yes, he's accepting it.
Okay, hold on.
Adjudication.
Just wait for the judge. Okay.
Does he have any priors?
Yes, Your Honor. Yes. I believe the defense counsel just stated he's willing to accept the state's offer of adjudication credit for time served.
Yes, and he is waiving the formal information requirement.
There's no statement order here, right?
Well, it would be a closed case.
Yeah, if he takes the plea, the case is closed, and there is no need for the stay away order.
I don't have a colloquy here.
Well, Judge, you would just need to advise him that he's waiving his right to go to trial, to be represented by an
Well,
attorney.
it's a little bit longer than that.
I mean, I can colloquy him, and if you
No, you're not gonna colloquy him.
I know, but if you can, like, it's up to you. He wants to accept the offer. Please, Jim.
We're gonna pass this case.
Absolutely.
We're gonna pass this case and call him back a bit later.
All right, she's going to pass the case and call it back later. It's the Courtroom Files Live. It's Tuesday. It's Veterans Day. So happy Veterans Day to everybody, especially those obviously involved with the military. So again, it's a quiet day out in the courts. As you would expect, not everybody is running, just kind of the ones that absolutely have to be, first appearance courts and stuff like that. So we've been a little bit live and a little bit in the Wayback Machine. But let's continue to be live, but we'll go back to back to Hillary Braley and that magistrate court. Spend a few minutes there again.
Now calling the people of the state of Michigan versus Willie Ethan Thorne, Police Agency Report number 25-13569. Can I have appearances for the record, please?
Yes, Your Honor. Katie Rozmersky for the people.
And Laura Yagi, Assistant Public Defender, requesting appointment to represent Mr. Willie Thorne.
Okay, thank you. And Attorney Yagi, can you address the plea?
Yes, we have reviewed the charge, so we waive the formal reading and we stand muted this time.
You, Mr. Thorne, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Any questions about your rights?
No, ma'am.
Because this charge is considered a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over. That is transferred to the circuit court, which is where your actual trial will take place. Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be November 20th. 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. So 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So can the attorneys address bond, please?
Yes, Your Honor, thank you for the opportunity. I would imagine that the court is in receipt of our bond form on this matter. I have had an opportunity to review the bond form. I've had an opportunity to briefly try to review the police report. It's a little lengthy, so I didn't get all of it. I will note that this is obviously a younger individual. He's 22 years of age, if I'm looking correctly, and there does not appear to be a criminal history. That being said, there's a $15,000 bond request, and I will indicate to the court I likely would have asked for at least that if I were the one filling out the form. I feel like I might even ask the court to consider 25,000. I'm not saying I ask that in every strangulation case because I do not. I will indicate in this instance, we are talking about two individuals that are strangers to one another. We are talking about a road rage incident that appears to have occurred in broad daylight, where the vehicle's pulled over and defendant strangled this other individual unknown to him prior to that, to the point literally of unconsciousness. The victim was taken to the hospital. Strangulations are always potentially lethal. When someone is rendered unconscious, you are seconds away from lethality. Judge, the seriousness of this offense is just shocking to me. I'm not certain that you have a way to keep the public safe, in my humble opinion, without imposing what I would consider to be a fairly significant cash requirement. So that is the underpinnings of my request. Certainly happy to answer any more questions if the court has any, but that's where I would come from. Thank you.
Yes, sir. I do see you have your hand raised. Let your attorney speak for you, please.
Thank you, Your Honor. So first, I know Mr. Thorne adamantly denies the allegations, indicates he has evidence that he's very much looking forward to present to the court in support of his innocence. I also want to note that this allegation is from July, so July 7th. So the fact that he's been out since July with no further allegations of criminal activity and no further allegations of any contact with this man who's making the allegations is an indication to the court that there are less restrictive means than a cash bond that can and will support the community and protect the individual in this case, because it's already been happening. So I also read the prosecutor's bond request as being an unsecured bond, which means, of course, that he wouldn't have to post that before being released. So the initial prosecutor who wrote this requested an unsecured bond, so is supporting Mr. Thorne's release. I think perhaps most significantly, and Mr. Thorne has never been in trouble before, so was completely unaware of how the system works. Unfortunately, he was arrested at the time his child is currently being born at the hospital. So his first baby is currently, his wife is, or not wife, but partner is in labor right now at the hospital. And he was very emotional and very devastated that he happened to be arrested at this time. It is very, unfortunate to say the least. He works at the U of M hospital, so he certainly does not pose any flight risk. He is expecting to take paternity leave, though, to help care for his baby. But I don't think this is an individual who poses a risk to the community. He's been in the community, has no priors. It seems whatever this charge is very much an isolated incident that, is alleged to have taken place from July, but nothing before or after shows that the court can release him on a personal bond with the standard conditions, which will protect both the community and the individual in this case. And again, he is very eager to, to tell his side of the story. I know that's probably why he raised his hand, is he wants to go into the details. I advise you again, Mr. Thorne, not to go into any details about what happened. I know the prosecutor made really serious accusations against you, but nothing you say at this time about what really happened is going to help, because the court is presuming your innocence. So
I just wanted to state, when the police questioned me, I had told them everything that happened.
I would not.
And then I'm just saying, like, I wasn't difficult with them in answering anything at all. I'm trying to be transparent as possible. I had even told the
Mr. Thorne, don't go into the details, because I know you want to, but today is not your trial. It's not a hearing about what
I know. I'm just saying, like, I'm trying to be as transparent as possible with everything, because I know you guys just need to know what happened. And I had even sent in a video.
But today is not, Mr. Thorne, today is not the time where the court does need to.
I'm so sorry. I'm so sorry. I'm just shaking up. My child is being born right now. And I'm sorry. I'm sorry.
And I will note, Attorney Rosmarsky, that the Attorney Yagi is correct in that it is marked as an unsecured appearance bond on the bond request form. So the court will set bond with the following conditions, Mr. Thorne. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create weapons. Any weapons that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You wait until the end, please. Thank you. You are not to have contact with the alleged victim in this case, that being Aso Hama. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. You are not to go to Mr. Hama's place of residence, place of work, any place you might frequent. When your court says do not go, the court does not care if you own a place, rent a place, or are personally invited to go to a place. Do not go.
Can you state the last thing you said one more time? I didn't hear it. I'm sorry.
What about not going and what that means?
No, it said you said something about going somewhere. I didn't hear it. I think the audio system lagged.
When the court tells you not to go someplace, the court doesn't care if you own that place, rent that place, or are personally invited to go to that place.
Okay.
Don't go.
Yes, ma'am. I just didn't hear it because the audio had on my side, it had cut out a little bit.
You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards Mr. Hama or anyone else. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being November 20th at 9 a.m. in person at 14A1. It looks like you also have a no insurance case out of 14A2.
Yeah, it should be the 18th or something like that.
Yes, thank you. But please don't interrupt, all right? But yes, glad you're already aware of that. Okay. Now, you had your hand up when I said not to leave the state of Michigan without the court's permission. What did you want to say?
I was gonna state that I was actually transferring my what's it called?
Resident.
I just recently bought a house in Toledo. So like I've been fixing that up, but I mean I do have a place in Michigan that I can stay because my parents live in Michigan. So I'm just gonna stay around there, you know. I was just trying to be specific, like I didn't, because you had stated that I can't go anywhere, even if it's my property. So I mean, you already answered my question, kind of.
But
So-
and I hate to jump in, but I think Mr. Thorne,
So if you have a place in Ohio that you're currently fixing up, then you may have the court's permission to go to Ohio to go to that residence. Right?
Yeah, because that's where all my baby stuff is, because I do have to grab like, you know, like their bassinet and just the diapers that we got gifted and stuff like that.
So you have the court's permission to go to Ohio. If you're going anywhere other than Ohio or Michigan, you need to contact your public defender and talk to them about how to get permission to do that.
Yes, ma'am.
Any other questions about the bond conditions?
No, ma'am.
These conditions will be entered into the law enforcement information network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $15,000 personal recognizance bond. So what that means is we're not paying anything to get out today. Basically, you are promising to appear for your next court dates and to abide by all of the bond conditions. If
Yes,
you
ma'am.
fail to appear or violate any bond conditions, then a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $15,000. You any questions about anything I just said?
No, ma'am.
Okay, and it sounds like you have one more reason coming into the world right now why you should abide by all of the bond conditions. So, okay. Anything else from the attorneys?
No, thank you.
No, thank you, Your Honor.
Okay, thank you. Then, Mr. Thorne, you are free to go to the door and tell the jail that you're finished.
Thank you, Your Honor.
As Michael points out in the chat, lots of superfluous information. Your Honor, my baby's stuff is down at our new house in Toledo. You know, I paid $47,294.50 for that home. It's about 11 and a half feet off the curb, which I found surprising because, you know, normally they're more like 15 feet, but things can get a little weird in Toledo sometimes. Anyways, let's way back machine it again. Let's go to Judge West and see what was going on in her court yesterday. Let's spend some time there.
And this is 24 DCCR 1151. Mr. Bruno was previously in court, entered a plea of guilty to evading arrest or detention with a motor vehicle. I have received that pre-sentence report. Has everyone had an opportunity to review the report? Are there any additions or corrections? Mr. Bruno, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, the case will actually be dismissed at the end. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would become a convicted felon, and you could be sent to prison for anywhere in the range of punishment, which is between 2 years and up to 10 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. See, Jose Contreras, Mr. Parker, it's also sentencing. Good morning, you're Jose Contreras. And Mr. Contreras, in cause number 25 DCCR 0006, was previously in court, entered a plea of guilty to the state jail felony offense of failure to comply with sex offender registration requirements. And I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Have your option state this.
Any additions or corrections?
No more of your open state.
All right, Mr. Contreras, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, obviously this is a great opportunity because you don't have this conviction on your record. And if you successfully complete the probation, the case will be dismissed and you'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon and sent to the state jail prison for up to 2 years. Do you understand? Obviously, you understand now the importance. If you move, I know things get, it looks like you were in the middle of some things. You cannot miss this reporting. Your reporting period is not that long. You've only got a couple more years, I think, on it. So make sure you do it properly between now and then, and you shouldn't have any issues. All right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to go over your paperwork when she's ready, okay? All right, good luck to you, sir.
Thank you.
Diamond Ollie. second. Give me just. Y'all are gonna have to give me a second because I just did something. I'm not quite sure. What'd you say? Oh, it's got, something's happening. Sorry.
This technology sure is good.
Isn't it great? Go paperless, they say. It'll be so much more efficient.
As a solo, I find this true. I can't imagine that it would go well.
Let's try this again. All right, your Diamond Ollie. And will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Ollie, in cause number 25, DCCR 0532, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual, and that's from February 1st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Speak up, please.
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. Is there no fine?
No fine.
And you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Ollie is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report done. It'll just give me more information about you and your case, and then we'll go forward with sentencing at a later date. You need to stop and talk to probation on your way out of the courtroom today to start that process, and she's sitting at that desk right over there.
Your Honor, this is her lawyer for the CPS case, and I've talked to the caseworker, and the caseworker has informed me that she has been working the program. She's done everything she's supposed to have done. There's only a couple things. It's her husband, who she's was recently married to, who's completing some of his classes, and she has other kids that she's seeing all the time, and she has this child she hasn't seen. And it upsets that kid when he sees the other kids leave. And we're wanting to see what we can do about reunification. That's the goal, what the court's position is on that. And she may be able to speak more to that than I
That's
can.
why I came, Judge, just to be a friend of the court, and I have emails from the caseworker too.
And if you, just for the record, if you'll state your name.
My name is Courtney Wheeler. I'm the attorney appointed to Ms. Ollie in her CPS case.
So what is the status with CPS with regard to contact between the child of the victim in this case?
The only reason that she's not getting contact with the child victim of this case is because it's part of her bond conditions that she can't. So it seems like both courts are at a bit of a stalemate, which is why I offered to come today. She has worked all of her services. She's completed everything except for the ones that are ongoing, like counseling, which she's participating in. Even though she doesn't get to see that particular child when she buys
stuff, supplies, food, snacks, toys for the two she gets to see. She includes him on absolute gifts are sent home.
How old is this child?
He's 5.
5. So here's what I will do. Mr. Hoffpower, do you have any issue if I make it just between now and sentencing at least supervised? And then once we get to sentencing, I can get more confirmation through the pre-sentence report of the status of everything?
Just for the court's information, the state's been included on all emails between CPS and Parker, so I know
Okay.
all what's going on. I'm okay with whatever the court decides.
So what I'll do at this point is modify the bond conditions, Ms. Ollie, to allow you to have contact with, is it Casey? Okay, and so, but it's going to be supervised only, and at least until we come back for sentencing, and then I'll decide at that point if it's still supervised for some amount of time or not, depending on all that information that I get. So for now, supervised with just as some competent adult. I'm sure you can talk to your attorney about what that means, and then we'll see where we get when we come back for sentencing. Okay, thank you for coming. And Ms. Ollie, make sure you stop and talk to probation on your way out. Okay, we'll see y'all back at sentencing. And Mr. Parker, you've got Stephen Wilburn, that's also a sentencing.
You don't have to do that for me, George.
All right, sir, you're Stephen Wilburn?
Yes, ma'am.
This is cause number 24, DCCR 2346. Mr. Wilburn was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
Nothing more, Judge.
Judge, although safety was not part of the original plea, obviously, of course, it's up to the court's discretion, and based on Mr. Riley being so thorough in his PSI, I would stand with his recommendation.
Your Honor,
Seeing as how he put it out in bold, et cetera, that safety or some other form of residential treatment proposed.
Your Honor, I would just point to the court that his last offense was 24 years ago, and he's got a full-time job. He worked for Performance.
Yes.
I think he's a welder.
Yes.
And we would ask that he not be sent to safety and be monitored some other way as far as his alcohol consumption. Obviously, he understands that he can't drink. He and I've talked about that.
Or possibly hold that in abeyance, Judge, if you're considering, so that, I mean, my concern is over the holiday period, if we're not here, it could be brought to the probation department's attention and in the courts, even if we're not talking.
All right, makes sense. So here's what I'm going to do, Mr. Wilburn. Obviously, you've had a very long-standing issue with, it appears to me, with alcoholism, and I understand that you're Mr. Parker's position. Your last DWI was a very long time ago, but your history prior to that was not good, and I don't want you to go down that same path, obviously. So what I'm going to do is I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, follow the agreement, and find you guilty of driving while intoxicated, third or more. Sentence you to a term of 10 years in prison, but probate that for 6 years. You will be ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That means some of those rules and conditions are the standard rules, but in addition, I am going to order that you enter and successfully complete the safety program, but I'm going to hold that in abeyance. What that means is that it's already ordered. If there's any hiccup at all, two things could happen. One, they could just send me over a piece of paper, it gets signed, you go to safety, period. I've already ordered it. Two, I don't have to do that. You could be revoked. So it's very important that you follow all of the rules. I am going to order that you enter and successfully complete the JCDI program. That is an outpatient, intensive outpatient treatment program. So you will be ordered to successfully complete that. You will get started on that. Your officer will let you know how to do that. I am also going to order, at least for some time, that you wear a scram device. That's a device that will detect alcohol in your system. If there is any alcohol in your system, obviously you're either in safety or you're in prison, one or the other, immediately. And so you need to get that scram device within 48 hours of today. They'll also let you know how to get that taken care of. And you're also ordered as a condition of your probation to serve 10 days in jail. That's required. And so what are your hours of work?
Right now, we're on 7/10s until after Christmas, but we are having 3 days off for Thanksgiving. I can start at them 3 days. I'm sure we'll have a few days off for Christmas.
Well, it's difficult to just say, okay, you're gonna do 3 here and 7 in a month or 2. I mean, obviously, I don't want you to lose your job, but we've got to get the 10 days done. So what I will do, I mean, you have some time off on vacation, things like that, that you can take. I don't mind doing a longer period of time over the Thanksgiving break and then I mean, do y'all want to look at a calendar and come up with 10 days, Mr. Parker?
Is it 10 days consecutive?
It does not have to be. No, you can do weekends, and I don't mind spreading it out a little bit, but I need specific dates. 10 specific dates between, I mean, we're already in November now and the end of the year. I wouldn't mind working a little bit around that, but I need the exact dates. So why don't y'all talk real quick about those dates, and then I'll recall the case and I'll put those on so we have those for the order. Mr. Rojas, you have Krisha Bennett, or Krishara, I'm sorry. Good morning. Good morning, ma'am. You're Krishara Bennett. And will your client waive the formal reading of the indictment?
She will, Your Honor. We'll email it.
Okay, thanks. Ms. Bennett, in cause number 25 DCCR 0062, you're charged with a third-degree felony offense of credit or debit card abuse against an elderly individual from November 14th of 2024. And how do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would not be a fine. You would be ordered to pay restitution in the amount of $2,256.92 and also to forfeit your home health aid license. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Bennett is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to the probation department on your way out of the courtroom today, and she's sitting at that desk right there.
Judge, may I just clarify for the record, whether she has a license or not? I know it reads that way, that she's not allowed at all based on the nature of the offense and stealing from her.
Yes, so you are not, as a condition of your bond right now, I'm going to make a condition of your bond that you are not allowed to provide any type of home health service, whether it's licensed or not. And then a condition of your probation will be the same. Obviously that you forfeit your license, but that you cannot go do this type of job even without a license. Do you understand? All right, stop and talk to probation on your way out of the courtroom, and then we'll see you at sentencing.
We've got the dates, Judge, when you're ready.
Okay, y'all can come back up on Stephen Wilburn. All right, this is back on the record, and what are the dates?
He wants to start November 26th at 6 p.m. And then he'll do 26 through 28. And then he'll do every weekend after that, reporting it Friday at 6 p.m.
So that every weekend then would start on the 5th of December. I mean, because the 28th is a Friday, so you don't want to go ahead and go through that weekend?
You're going to do Get Out Sunday, correct?
Yes.
So it would be the 26th through the 30th then?
So is the 30th a Sunday?
Mhm.
Yeah, you Get Out Sunday, yes.
Okay, so the 26th through the 30th, so we've got 26, that's 4 days. And then we need every weekend, starting December 5th, until it's satisfied. So you will report then on Wednesday, November 26th at 6 p.m. You'll serve 4 days to be released on Sunday the 30th. Then you will report back that next weekend, Friday at 5 o'clock. They'll let you out on Sunday, and that will be until you complete the remainder of those 6 days. It's important that you are on time, not late, that you show up every Friday. It's a condition of your probation, so if you don't show up or you're late, then you're in violation of your probation. It's also very important that you don't show up intoxicated. Some people think it's a great idea to show up drunk. They're going to sleep it off while they're there. That's a violation, so don't do that as well, okay? All right, have a seat here in the courtroom. Probation will call you up. Actually, hold on, I didn't finish this. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir.
Okie dokie, friends, that's the logical place to leave it for today, and pretty much right on schedule. I'm so glad to be back. You know, the 2 weeks off was very much needed, except for those last couple of days where things went all kittywonkus. But so I mean, I feel fresh, and that's great. But you miss not being in the chair, and you miss not interacting with you guys. Even though it was a quieter day today, it just reminded me that I very much missed all of you. So thanks for having me back, and not revolting and demanding that Michael take over the channel. But thank you, Michael, again for taking care of me those last couple of weeks. Very much appreciated. So we'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Sidebar is already posted, so you can go to the channel and click on the notify me so that you get an alert. But even better, if you're not already there, go over to the Discord server, sign up there so you will never miss an alert from us. And that is in the pinned chat. But look forward to seeing you there tonight, and then we'll see you tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members for the morning show, where we should have a lot more live content once we're clear of the Veterans Day holiday today. So go make it a great day, because each day is special as long as you allow it to be. So have a good one. Take care. God bless.